including state witnesses. 44. I have no intention to destroy any evidence that may be required by the state for this matter. 49. As a student, I intend to participate in academic activities, including end-of-the-year examinations. Should I not be granted bail, I will suffer irreparable harm, as I will not be able to complete my studies before finalization of this matter. As already stated, our fight is for free education. The free education can only be achieved in the classroom and through dialogue with all affected parties, not through repression and state-sponsored violence against students. Lastly, paragraph 51. There is nobody who wants to return to class and normality more than the protesting students. We, however, will do so upon being seriously engaged on our demands by both the university administrators and government. It is not expected of this court to consider the merits or demerits of the Fees Must Fall campaign. The court will, for purposes of this application, accept that the concerns and demands of the Fees Must Fall movement are indeed justifiable. The court is also not called upon to determine whether the applicant is guilty of the allegations leveled against him, but to determine whether the interests of justice permit his release from detention. In doing that, it is necessary to weigh up the personal freedom of the applicant against the interest of justice. It is not only the interest of the applicant that needs to be considered, but also the interest of the complainants, as well as the interest of the community served by this court. The crimes alleged to be committed by the applicant are not only crimes in respect of the complainants, but also in a wider sense, crimes against the community served by this court. Our Constitution affords the applicant certain rights inter alia: the right to freedom of expression, the right to freedom of association, the right to assemble, to demonstrate, to picket, and to present petitions. And lastly, in respect of education, the Bill of Rights in the Constitution also guarantees certain rights, like the right to basic education, the right to further education, etc. None of these rights are, however, absolute and are subject to limitations. Section 36 of our Constitution contains a general limitation clause regarding the rights referred to. It emerged from the evidence that it is common cause that the applicant was actively involved in a leadership role to further the goals of the Fees Must Fall movement at the university. The applicant referred to himself as one of the co-leaders of the said movement. It also emerged from the affidavit of the applicant that their demands addressed to other role players, for instance, like the university, were frustrated and not met. The result thereof was that the campaign became violent to such an extent that the university had to approach the courts for a court order, as referred to earlier. The applicant maintained that he at all times advocated a peaceful, non-violent protest. He also maintained that the allegations leveled against him were fabricated. The evidence of the applicant, as contained in his affidavit, is not convincing. It's highly unlikely and improbable, and is also not consistent with the facts as placed before the court. The two photographs of the applicant, namely Exhibit C1 and C2, are damning evidence against the applicant. It depicts the applicant in possession of an object resembling a rock stone aimed in the direction of a police vehicle. It is unlikely that the university would have approached the court for relief if there was no violent protest causing damage to their property and affecting the rights of others not participating in the Fees Must Fall movement's protests. Common sense dictates that the members of the police force that were present would not have got engaged in acts of violence towards the applicant and co-members of the Fees Must Fall movement. They were present not by choice, but on instruction to maintain law and order. There would have been no need for them to be present in the event of peaceful, non-violent protests. The court is of the view that the applicant was not always frank and honest with the court. It was, for instance, submitted by the applicant that it would have been to his detriment if not released, as he had to write a test on the 18th of October 2016, namely for the course law of evidence. Subsequent to that, it was discovered that he is not registered for the said course, and that no tests for the said course was scheduled as claimed by the applicant. The version of the applicant that he was unaware of the existence of the court order referred to is inconsistent with the facts placed before the court. It's devoid from any logic. The applicant was one of the co-leaders of the Fees Must Fall movement. It is unlikely that he, as one of the leaders of the Z movement, would not have had knowledge of the court order, especially as the court order was granted on 25 April 2016. Section 60, subsection 4A of Act 51 of 1977 stipulates that it is not in the interest of justice to release the applicant from detention in the event of a likelihood that the applicant, if released on bail, will endanger the safety of the public or any particular person, or will commit a Schedule 1 offence. Section 60, subsection 4, likewise stipulates that it is not in the interest of justice to release the applicant from detention where exceptional circumstances exist and where there is a likelihood that the release of the applicant will disturb the public order or undermine the public peace or security. The exceptional circumstances in this instance will then be the prevailing circumstances that exist and existed at the campus of the university. The inference is inescapable that the applicant has a tendency to commit the type of offences as leveled against him. There is no basis for a belief, as suggested by the applicant, that he was arrested simply because he is one of the leaders of the Fees Must Fall movement. The court is satisfied that it was shown that it would not be in the interest of justice to release the applicant on bail. The right to apply for bail to secure his release from detention is not an absolute right. It is subject to limitations. The application by the applicant for his release on bail is therefore refused. Sir, your case is then postponed as arranged with your legal representative. It is postponed until the 15th of November 2016. You will appear in court number 10. It is to complete the investigation, and you will remain in detention.